What's going on, everybody? Welcome back to the channel. Welcome back to Alfonso Speaks, and welcome back to more Darrell Brooks content. We're diving right back in to the 50-minute rant. We did part 1. If you haven't seen that, check it out. But we're going to try to get through the rest of this today. I don't want to stay on this 50-minute rant for too many more episodes. So we're going to try to knock it all out right here, right now. This is going to be a longer episode. There's about, I want to say, 40 minutes or so left in his rant. So what we're going to see here is the rest of that rant. I'm going to break it down, pause a little bit to talk at certain points, but I'm going to let the video play for, the majority. And we're going to also see what Attorney Sue Opper's response was to Darrell Brooks and how he reacted to that response. So let's check it out, guys.
Present in the courtroom, the question is shut down, which is a valid question. The plaintiff should be present in this matter. Where is the plaintiff? Who's bringing the claim? Because we know an entity can't bring a claim. It has to be a living, breathing human being. No one is stated for the record if they're the injured party. Not Your Honor, not the prosecutors, not anyone in the court has stated to be an injured party in this matter. No one. Not one person.
I spoke about how ridiculous and disrespectful him saying that in front of a court full of the family and victims truly is. I spoke on that in the previous video. So if you guys want to see how much that aggravated me and annoyed me, just go ahead and check that video out.
I have the right to demand that the court place in the evidence any unrevealed contract. Has that been provided to me? Have that been placed in the evidence? I would like to see it, which is my right. I have the right to inform the jury about the truth and their duty and their rights. That's the First Amendment and the Sixth Amendment. But I'm repeatedly told to shut the question down when this is valuable information that the jury should be privileged to know. They deserve to know.
What he's talking about right here is that he kept trying to bring up the fact that a jury can nullify the law. So basically what that means is, I don't know, say I walk in on somebody attacking my wife, for example, and I bludgeon them to death, and I'm charged with homicide or manslaughter, or whatever the case may be. A jury can then decide that they don't agree with the law, how it's being enforced in this situation, and I can walk free, on that technicality. He is trying to get the jury to basically nullify the law. It's called jury nullification. He's trying to get them to nullify the law so that the charges against him don't land him in prison because the jury doesn't agree with the law, which is not going to work. I don't understand that approach at all. That has no chance of working. You ran through an entire city basically, and now you're facing a jury of people from that city. Would you think they're going to nullify the law? Come on, bro.
Once they were chosen to sit on this jury, why are we keeping information away from them that they deserve to know?
I actually don't believe he actually thinks that was going to work. I just think he's time wasting once again.
They ultimately have the power. They decide the matter. Why are we keeping information, valuable information, from their knowledge? That's a disservice to the jury. And frankly, it's a disservice to the court that they're not allowed to hear things that they should know, that they should be informed of. It's our right to inform them of everything that they have the power to know, to do, and to know. They deserve that much. It would be a travesty for them to make a decision without being fully informed. And these are all valid things. I have the right to protest and object if any of my rights or demands are not being met. I've done that numerous times only to be shut down. numerous times. I've raised the issues that I didn't consent to anything that may have been suggested on behalf of my former attorneys. I've never even consented to them making a plea on my behalf. I haven't, as a matter of fact, when it comes to a plea, I haven't even had the opportunity to entertain any plea that may have been suggested by the prosecution. We haven't even talked about that. Not one time was it ever brought to my attention that the prosecution even wanted to offer a plea. That's another issue. I have the right to challenge the jurisdiction of this court, which I've done numerous times. I have the right to demand that the code be construed in harmony with the common law. I just raised that. I'm constantly referred to as pro se when I've raised the issue that I'm pro per. I have the right to conduct my defense pro per free from professional restrictions imposed upon licensed attorneys, which this court is well aware that I am not a licensed attorney. In fact, the court is also aware that I only had 3 days to prepare for a trial that the prosecution has been prepared for a whole year.
So this is a great example of narrative spinning right here. This one right here. He said he only had 3 days to prepare for a trial that the state has been preparing for an entire calendar year. Technically, yes, that's true. But the only reason that that's true is because Darrell Brooks allowed the attorneys that were going to be representing him to prepare for the trial for almost a year before he fired them right before the trial started. So yeah, he only had 3 days to get prepared with all the information that the attorneys had already collected for him. They had already done all the heavy lifting, done all the work, done all the preparation. He fires them right before the trial and then tries to claim that he didn't have enough time to get ready. You could have fired them a long time ago if that's what you wanted to do, but that's not what you decided to do. You decided to wait right before the trial so that they could collect everything for you that you would need. And you could go in and just piggyback off of all their hard work. And now you're claiming that you only had 3 days. It's not going to stick.
We see these boxes right here. This box alone is 45 or 50 pounds full of so much information. I haven't even gone through half of it. It was stated for the record that the discovery, in its entirety, was brung to my housing unit on the 29th of September, which trial was scheduled, that would be a Thursday, which trial was scheduled for Monday. How can I possibly go through all that, all the paperwork, all the digital discovery and things of that nature? How can I go through all of that and be prepared in 3 days? That's a clear bias. I did not have time to prepare for this. Everything I'm doing is off the top of my head, winging it, taking it as it comes. When the court is well aware that I was not prepared, I raised the issue that it should be an adjournment, at least. At the minimum, it should be an adjournment because of that fact. At least to let me go through all the discovery. That was denied. No valid reason was stated for that when Your Honor knew there is no possible way, humanly possible, that I could be ready for a trial of this magnitude in 3 days. That's clear bias. I have the right to face the injured party claiming damages. That's under Article 3 and the 6th Amendment. I raised that issue again. Where's the injured party? Is the injured party present in court right now?
As I mentioned in the first video, you're going to notice he starts repeating the same points over and over again because he's time wasting. Again, his tactic was to delay, to try to push this trial back as far as he could, because every day he spends in this court is one less day he has to spend in federal prison. So you'll notice he's trying to waste as much time as he possibly can every single day.
Can anyone make a claim against me? Can you make a claim against me, Your Honor? Do you know of anyone that can make a claim against me, Your Honor? Can anyone right now in court, anyone, make a claim against me?
See, that's crazy. That's the crazy part right there. Can anyone in court right now? He's talking to everybody. So that means the victim sitting behind him, yes, they can make a claim against you. They already have. That's why you're sitting in the chair.
And because of that, Your Honor, the motion to dismiss should be granted based on that alone. There's no injured party in this matter. So who makes the claim? Who? I have the right to put the judge on notice of my intent to appeal and any ruling decisions during the case. You stated for the record that I would have to wait until appealing process, but my right is that I can raise that issue during the case, which I've attempted to do. That's been shut down. I have the right to specifically reserve all of my rights, which I do at the beginning. I have the right to say what I want and to be heard under the First Amendment. And when I attempt to do that, it's taken as a slight to the court, a disrespect to the court, or me intentionally coming into the court to be disrespectful, which I've stated that is not my intention. Never is it my intention. I never intend to walk into your courtroom, Your Honor, and be disrespectful intentionally. I never come into this courtroom to disrespect anyone. But because I don't understand, I raise these issues because they have validity. I have the right to object to any statement made by the judge or the prosecution. I've done that and been repeatedly shut down. Without a lawful explanation. I've repeatedly asked the court for a motion for a finding of fact to determine if things are being done legally. I've been denied that numerous times without merit, which is also my right. I have the right to recuse the judge at any time, which is also a right. I have the right to a speedy and fair trial by impartial jury. I think it's safe to say that my speedy trial right has definitely been violated because this matter has been taking place for roughly a year. I've never consented to waiving anything related to a speedy trial. And if that was done, it was done without my consent or without my knowledge. We're way past the speedy trial date. Way past. When the change of venue motion was brought up, I believe that was the first time I came before Your Honor in early March. I want to say March 11th of this year, when the change of venue motion came into play. It was decided by Your Honor that wouldn't be decided until the 20th of June, I believe. That's over the 90-day mark right there for a speedy trial. That was denied, and I still don't understand how that was denied when it's clearly obvious that at minimum the venue should have been changed based on the fact of the magnitude of the matter. There's no possible way anyone in this county would not have some type of connection or some type of knowledge, whether they were told something by someone that they may know, the news reporting alone, just that alone, there's no way that this trial should be taking place in Waukesha County.
Okay, so this was probably the only point in the 50-minute rant where I was like, okay, he has a little bit of a point here. You know, like Waukesha is not a big area. So the odds of somebody being on the jury who has no idea about the parade attack and can come in completely impartial is very low. But my response to this is, who cares, bro? You got caught in 4K. Any court in America would have found you guilty of this because all the evidence was overwhelming. There was nothing that was going to prevent you from going to prison for this for the rest of your life. Now, the change of venue, not a change of jury, not a quick and speedy trial, nothing would have saved you. So while he has a good point, in my opinion, I want to be fair. He does have a good point about maybe the change of venue should have been granted. Who cares? Who cares? Cry me a river. That's pretty much my entire response to that.
That's obvious. That's obvious from the way the motion was presented, the coverage alone, the political campaign ads that plastered the defendant's face all over the TV every single day. Every time a political campaign was brought up, it made reference to this incident. Every single time. The fact that people have children that go to the same schools in this county, that people may have worked with the same people in this county. You yourself, Your Honor, stated that you at one time worked with the father of one of the people that was injured in this matter. That is a clear conflict of interest right there. You also stated for the record that not only did you work with this father, but that at one time they may have donated to I don't know if it was to you becoming a judge or I would have to look through the docket, but you said it on the record that they donated money to a cause of yours. You also stated that when you had gained knowledge of the incident and that their family member was injured in the incident, that you reached out via phone. I don't recall if it was text message or an actual phone conversation, but you put that on the record. You also stated that the nature of your relationship was strictly professional. I don't know about you, Your Honor, but I've worked numerous jobs and I know what professional relationships is and personal relationships. I've never had the cell phone number of anyone that was a personal relationship saved to my phone that I could reach out immediately when I learned something.
He meant to say professional. I've never had a professional relationship where I could have their number saved. He's such an idiot. He doesn't even hear what he's saying before he says it.
Personal relationship of some kind, whether hanging out from time to time, having a cup of coffee, or hanging out time from time, grabbing a beer, or hanging out from time to time, watching a game, or anything of that nature. It would definitely be more than just strictly professional. That was stated for the record. Again, I go back to the Sixth Amendment again. In terms of when I asked for the motion for the evidence motion that I raised, that was denied without any explanation. That would be strictly to place in the evidence any unrevealed contract. That's under the Sixth Amendment. Clearly, there's been repeated violations of my Sixth Amendment. We all know that the United States Constitution is the law of the land, period. It trumps everything. We also know that any law repugnant of the Constitution is null and void.
So again, I spoke about this in, I think, the first episode that I put out about this trial. How can you claim to be a sovereign citizen and then bring up the Constitution in defense of yourself? Because as a sovereign citizen, which, by the way, carries no weight in a courtroom, you're not under the jurisdiction of the Constitution. It doesn't apply to you. So you can't have it both ways where you don't have to follow the Constitution, but everybody else has to follow it when it comes to your rights. That doesn't make sense. It doesn't work like that.
We know that. There's still no basis for the motions being shot down. Why was I not granted the motion for finding a fact? Why did it take so long for me to be brought my entire motion for discovery? Why was the motion to prove jurisdiction not verified? Why was the motion to dismiss the case for all the reasons I said not being granted? Which brings me to the motion to subpoena witnesses. I did everything that was asked of me by the court pertaining to those subpoenas. It was understood by the court that this is my first time ever having to do this. I didn't understand how to properly fill out the subpoenas, at which the prosecution volunteered that they would give assistance. The only assistance I received was for them to check to see if it was filled out right. That was it. That doesn't amount to any assistance. I was still left to fill it out on my own, and then...
You're representing yourself. You made this decision. You had attorneys that could have done this for you, but you fired them. And so now your sense of entitlement is taking over, where you feel entitled to the fact that the state has to help you defend yourself. That doesn't make sense. They're going against you. It's state versus Darrell Brooks, not state with Darrell Brooks. So they're not required to help you. This is, honestly, this part that he brings up, this legal argument that he brings up, really is just another showcase into his character. He is entitled. He's grown up as a spoiled, entitled brat. He's never matured to the point where he knows that he needs to take responsibility for himself and do things himself. And again, we're going to get more into that when we start talking about his upbringing, especially with his mother.
And when I did that, corrections still had to be made, which would verify what I was saying. I don't know how to do this. But I still complied to what the court asked of me. And even then, it was a big old thing about the subpoenas. I can't subpoena the plaintiff in the case. Well, how can I not subpoena the plaintiff in the case when under the Sixth Amendment, I have the right to face my accuser, which is the plaintiff of the case? So how could the subpoena not be filed? And how could the plaintiff not be called to the witness stand?
He wants the state of Wisconsin called to the witness stand. The plaintiff. I don't even feel like I need to go into detail about why you're not going to call the plaintiff to the stand in a homicide trial. I would go into detail, but you guys are smart. You're smarter than Darrell Brooks, so I don't really need to do that. You know where I'm going.
That begs the question of, does the plaintiff even exist? Which it was stated for the record that not only by a witness, a Detective Casey, that got on the stand and said on the record that is an entity, which is not a living, breathing human being. And then it was stated again by you on the record, Your Honor, that the plaintiff is an entity. So the question still stands. How can an entity bring a claim if it's not a living human being? So where's the claim? Will the plaintiff in this matter, the state of Wisconsin, be allowed to testify? Would they be allowed to be in the courtroom? No, they will not, because they don't exist. Therefore, the claim doesn't exist. For all those reasons that I just stated, the case should have been dismissed a long time ago. Once those issues were raised, this case should have been dismissed. And at the very minimum, it should have been dismissed because those still have yet to be proven. We're still talking about jurisdiction. That's been being asked for over a week. There's still no providing of license to practice law yet. Not even by you, Your Honor. Why was I not provided with a certified copy of your oath of office? Why would you not state the name that is on file with the Secretary of the State? Or I made reference the first time to the Secretary of the Treasury, and then you stated on the record that it's the Secretary of State, even though you knew what I was referring to when I asked. You referred to your name tag, but that's not the name registered. We both know that. So why wasn't that proof verified? You gave me a copy of your oath of office, but it's not certified. So how can I verify that that is the true oath of office that you signed? How can I verify that it's valid? That's the reason why I asked for it to be certified, which you stated for the record you will not do that. You never stated any legal reason why. I have the right to ask for that legally. I also have the right to call any witnesses to assist my defense, which is the main reason why I subpoenaed the plaintiff in this matter. I also have the right to challenge all relevant laws in this trial in terms of their intent, interpretation, fairness, enforcement, and whether they serve and protect the people. From my knowledge, the design of the statutes of the law was written for the common people to understand. So that would mean the final determination or interpretation of what the law says comes down to the people. You know this, Your Honor. Are you not a public servant?
You know, he keeps saying stuff, hoping for a response from somebody, and nobody gives him one for almost an hour. And you could just see how awkward it makes him feel. So he just starts going to the next thing so that he feels like he's still in control, because he's trying to push buttons and nobody's responding. Nobody's like really feeding into what it is that he's saying. He's taken multiple shots at the judge during this rant. He's taken multiple shots at the state during this rant. And they're just not responding at all. They're just letting him, you know, just keep going and going and going, have his moment. And, you know, he doesn't know what to do with that. Like, usually when he was a free man, if he starts pushing buttons, he can wait for somebody to give him a response, and then he can start playing victim. But it's not happening. It's not happening in this court.
You also know that this docket sheet is inaccurate.
See how he wasted time trying to find something else to talk about. It's getting ridiculous at this point.
Every filing up until the point that I started representing myself was filed in a name that was represented by all capital letters, which is not my name. Nor has it ever been my name, nor have I ever seen that name or individual. Every single filing or paperwork was all in capital letters. Ever since September 29th, roughly around there, now everything starts to go to lowercase letters. Why is that? What prompted the sudden change?
He's lawyering, guys.
I still have filings that have all capital letters, which I state every time I come into your courtroom, Your Honor, that is not my name, nor do I consent or agree to being called that name. I'm merely here as a third-party intervener on behalf of my client. Did I accept for value in return for value? We go through this every time I come here. Every time. You bring up Illinois versus Allen when we had the issue of me being removed from the courtroom. We went through that where Illinois versus Allen states that there are 3 options when a defendant is being disruptive in court. You stated for the record that you identified a 4th one, which is not cited anywhere in that case.
Do y'all see his fingers? Just look at his fingers, man. Like they're like very, very bony. They're like Voldemort fingers. Like if you guys ever seen Voldemort's wand, it's like made out of bone, basically. Like that's what his fingers look like. They're just weird, man.
It's not cited anywhere. So the question would be, how did you come up with a 4th option that's not written in that case? Did you take it upon yourself to add this 4th option to justify denying me my constitutional right by being present? You could have done the 3 that were stated. Any one of the 3 you could have done that were stated in the case. Nowhere does it say you can create a 4th option.
By the way, she did not create a 4th option. It's literally stated in Illinois versus Allen that a disruptive defendant, or honestly a disruptive anything, plaintiff or defendant, can be placed in a separate courtroom with audio and visual capabilities, and they can participate in trial from there, which is what she's been having them do.
Not upholding my constitutional rights. I'm sure you know about Title 18, USCS 2381, which states that it's treason not to uphold your oath of office. Treason.
Again, trying to get a response.
You repeatedly make judicial determinations that clearly prejudice my defense. And then when I question you about, are you making judicial determinations, I'm repeatedly shut down. Which leads to today. The constant push not to have an informed jury. Not giving legal valid grounds on objections, not noting objections for the record to make sure that the record is clear. I'm sure somewhere in the jury instructions, you informed them that the state of Wisconsin was bringing the claim. But then you make the judicial determination that I'm not allowed to ask questions about the plaintiff. That's clear bias. And it prejudices my defense.
Words are hard.
You know also that you have an electronic filing system. I find it hard to believe that I was told yesterday about my subpoena for the plaintiff that I had to wait for a filing in a timestamp when I've seen it done numerous times in just a few seconds right in front of my face. When the prosecution needs something filed, it's filed immediately. I have to wait, or I have to wait to the next day. That's a clear bias and a clear prejudice to my defense.
Inaccurate.
Obviously, the court knows that I'm not privileged to the same filing system. Which brings me to the reason why I brought up the issue of assistance of counsel. Under the Sixth Amendment, I have the right to assistance of counsel. It doesn't say anything about representing yourself without assistance of counsel. Having counsel represent you and having assistance of counsel is two totally different things. You, Your Honor, gave me paperwork that was a waiver of counsel. We both know that any contract can be altered if I don't agree to certain terms. I crossed out everything in that paperwork that I did not agree or consent to, and specifically wrote on that paperwork that I do not waive my right to assistance of counsel. At the very least, I should have been awarded a standby counsel. Not someone to represent me, to speak for me, but someone to help me do things in a timely fashion. Get things filed in a timely fashion. Get motions together in a timely fashion. Make preparations to get things done that I don't have the privilege to do in my current situation of being housed at the Waukesha County Jail. I gave you back that paperwork and you accepted the paperwork that I altered, that you understood that I didn't agree and consent to those things that were altered. You accepted it and you filed it. That is in the record. I have copies of the same paperwork that you accepted. So when you accepted that, with no objection, that becomes a tacit agreement. But yet, I'm still forced to come in here with zero help. I think it's clear that prejudiced my defense. knowing that the prosecution has everything that they need for this matter at their fingertips. And I have to jump through every hoop possible to even get things filed in a timely fashion. It was stated for the record that the unit that I'm housed in the Waukesha County Jail, and per Jail Administrator Angela Wallenhoff, that I'm only allowed out of my cell for a few hours a day. So I'm roughly locked down 22 hours a day, not given the privilege to access everything that I should be able to at the time that I should be if I was general population. Arrangements could have been made months ago for me to be at least in some form general population with an upcoming trial. Reference was made to being able to use LexisNexis or whatever it's called. We call it the law library. That may be the easier way to describe it. I'm only allowed to access the law library at certain times during the day. The rule of the jail is that when you're not in the day room, you can't access the law library, which is on tablets. We are not allowed to have those tablets in our cells. That prejudiced my defense. How can I work on my case? How can I look up certain case laws? How can I do any of this if I don't have full access to it? I even suggested some type of order that could be made by the court to allow me more time out of my cell, or to talk to jail administration about allowing me more time out of my cell to be able to use those when needed. And to be frank, in a proceeding of this magnitude, there should not be even a time where I don't have access to the materials that I need. If I'm not in the courtroom or sleeping, I should be awarded the time to work on this case, seeing as how I only had a couple days to prepare for a trial of this magnitude. Which brings me back again to the change of venue again.
Boom. More time wasting. He's running out of things to say, so he's going back to stuff. We already talked about the change of venue, but he's going to do it again.
Even right now with trial going on, there's still political ads being shown every day that reference this incident. There's still talk throughout the jail about it.
And this is where he starts getting to a point where he's not even making like real courtroom legal arguments anymore that are relevant to anything that the judge can make determinations on. He's going to start venting about his family situation and the ads that are being, run politically that smear his name and blah, 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 and this and that. And nothing that even if they did have any standing, the judge would be able to do anything about, because it's not relevant to what's going on in the courtroom.
There's been a ton of hate mail received to the jail since the beginning of this. It did die down for a little bit, but it picked right back up the closer we got to the trial. Hate mail that comes from people right here in the city of Waukesha. Which gives more credibility to the venue needing to be changed. Yet and still, that was denied. It's impossible for impartial jury to be found in this county. And that's not to discredit people in the county that can be impartial.
That's literally what you're doing, though, is you're discrediting the people that can be impartial by saying it's impossible to find an impartial jury in this county. Which, again, I don't think he's wrong. I just don't care.
It would be unfair to say that no one can be impartial. That wouldn't be accurate. But with the level of scrutiny that this whole incident has, the reporting, the Facebook groups, the constant, there were Facebook groups created because of this. The reporting live stream on Court TV has comment sections where a lot of insensitive and nasty things are said. The sheer insensitivity of some of the things that are said on there. I know a lot of people probably don't care about what I'm about to say, but it still needs to be said because it's truth.
Here we go.
The fact of the matter is, that I have children too. Family too, loved ones too. That also have been ridiculed and had their names drugged to the mud and have threats towards them.
It's like he's saying all this stuff, but like, bro, you're ignoring the fact that like your actions is what caused all this to happen to everybody. To yourself, to your family, to your friends, to your loved ones, to the city of Waukesha, to all the victims, all their families, the 6 that lost their lives. It's all because of you. You did this. And it was completely unnecessary. There was nothing that forced you to go down that parade route. Like, you did it all yourself, and yet here you are complaining about the after effects of it. There would be no after effects if you hadn't done what you did. Accountability. Like I said, he can't do it.
Loved ones that had to leave their home because they were getting threats thrown through their mailbox. Children that didn't feel safe going to school because they were getting bullied behind what was being said. And that's not to sweep anything under the rug whatsoever. To constantly say and report this incident as attack, terrorism. It's unfair and it's insensitive. It's a definite tragedy, definite. And that will never be swept under the rug. There's always going to be healing that has to take place. It's going to be difficult. And that should not be swept under the rug whatsoever. But it's very insensitive and unfair to not recognize that there's many other victims that never is talked about. And for people to paint a certain picture, mostly from this county, to put this picture out there, it's not only hurtful, but it's insensitive and it's not true. I'm sure the court read through the motion for change of venue. I'm assuming, though it was a lot of paperwork in those motions. I think it was obvious that the venue should have been changed. Obvious. It's too many connections and it's too close. It's too close. If there was any chance for a fair trial and an impartial jury, it should not have been in this county. But yet it was denied without any validity. Zero. There's so much bias that's going on that
he didn't finish his sentence.
And even with all this, for the record, we still have no proof of jurisdiction. We still have no bond on file in the docket sheet.
Okay, so I think we've watched about probably at least like 45 minutes of this. We're going to skip ahead to the part where Attorney Sue Opper gives her response.
Mr. Brooks, I've given you about 50 minutes to make your various arguments. You've now repeated yourself a number of times, so I'm going to turn to the state to see if they have any response. Go ahead.
Thank you, Judge. Judge, I'm going to summarize what I just heard by quoting from a case from the Eastern District of Wisconsin, federal case found at 2022 Westlaw 3045190.
Can you repeat that last
I'm
one?
so sorry. 3045190. Retzloff versus Moran. This case is talking about many of the topics that Mr. Brooks has now recited to the court, and simply states the majority of Retzloff's filing is incomprehensible jargon and cut and paste legal mumbo jumbo. Sovereign citizen theories are frivolous and wholly without merit. The court goes on to cite to Bay, B-E-Y, versus the state of Indiana at 847, Fed 3rd, 559, on pages 559 through 560, a 7th Circuit Court of Appeals decision from 2017. Mr. Brooks knowingly
being called that name, nor do I know any individual by that name, Your Honor.
Please do the courtesy of not interrupting the state, as they did not interrupt you for over the almost 50 minutes that you spoke. Thank you. Please continue.
Your Honor, the record is very clear that Mr. Brooks knowingly, willingly, voluntarily, and intelligently insisted on representing himself in this trial. He has no constitutional right to stand by counsel, none whatsoever. The court patiently went through the form and advised him of many of the things he's complaining about here today: the resources of the state, the knowledge of the law, his ignorance of the law. And his words to this court, and I quote to the best of my ability, "It don't make me flinch one bit." That's what he told this court, whatever it was, 2 weeks ago. Now he's here complaining over and over and over again how unfair this is to him. It's highly offensive. I don't know, because unfortunately I was talking to my investigator if he accused this court of treason, but I certainly heard that word come out of his mouth, and it is absolutely shocking that he would throw such a word around so loosely in this courtroom. This court has been exceedingly patient, exceedingly respectful of his rights at every turn. At every turn. I want to address this claim that he only had 3 days to prepare for trial. It's absolutely a false statement. The record should reflect that he does have 3 banker's boxes on his table. The record should reflect that every time the state calls a witness to the stand, he swiftly and easily turns to those boxes, which appear to be alphabetized or organized in some fashion by the public defenders who turned it over to him, and quickly removes the folder of the witness who's testifying and effectively cross-examines that witness using notes from the public defender. We know that because he's tried to confront witnesses with the notes from the public defender. He is not going into this blind or with one arm tied behind his back. They did all the homework, and he's simply sitting here reading their notes, reading their cross-examination questions, and asking the questions, and then going on to his ridiculous questions having to do with his belief in the sovereign citizen movement. There's no way this record would reflect that this defendant is not adequately prepared for trial. He's never asked for a speedy trial. He makes conflicting statements. On one hand, you violated his rights because it's taken us so long to get to trial, and on the other hand, we're rushing him to this case and he hasn't had adequate time to prepare. He is not denied access to legal materials in the jail. The record is very clear from the jail administrator. It should not be confused. He misleads this court intentionally to say, I only get out of my cell 2 hours a day. That is a fact. That is for his own safety, so that other inmates do not inflict physical harm upon him. He has access to a tablet. He has access to a computer. Whether he chooses to ask for those resources is up to him. I would also cite the court to U.S. ex rel. George versus Lane, Lane, 7th Circuit Court of Appeals at 718 Fed 2nd 226, where a pro se defendant attempted to complain on appeal about his lack of access to a computerized legal research system, paralegal training, or law school education. The court rejected that contention and said, once a defendant has asserted his right to refuse counsel and conduct his own defense, he has no constitutional right to access those resources. And again, you warned him, Judge. You fairly warned him. And he basically acted as if you were insulting him and said it didn't make him flinch one bit.
So, that is the response that Attorney Sue Opper had to that 50-minute rant that Darrell Brooks had. And look, this 50-minute rant paints the picture of so many things. Who he is as a person, Attorney Sue Opper's temperament when it comes to him, and really just how the trial went overall. Like, these are things that he kept trying to, he was big on like the technicalities, like trying to catch people on the little stuff to get a mistrial. There was no evidence that could have supported him being innocent of this parade attack. His only strategy, and this is why I said in the first video, I think it was actually very smart on his end to represent himself and try for this approach, because them attorneys were not going to be able to get him out of this. The evidence was too overwhelming. It was just way too overwhelming. But his problem is, he thought he was the smartest person in the room while trying to portray himself as the dumbest person in the room, but also the smartest person in the room at the same time. He's a walking contradiction. And because he's a walking contradiction, he had no game plan. He had no strategy. He wasn't organized. His strategy, yes, was to try to cause a mistrial, but he didn't have a game plan, I should say. He had a strategy, but not a game plan. Not an effective one. And it was one that was immediately seen by not only the judge, but the public defendants and everybody watching the trial around the world. And it was dealt with immediately. So then out the window went his ability to try to cause a mistrial, because everybody understood what he was trying to do. He got caught on jail phone calls saying, I'm going to try to get this trial delayed. How stupid can you be? You got to be smarter than that. But hey, maybe if he was that smart, he wouldn't have ran through the parade in the first place. But that's it for this episode of the Darrell Brooks trial and Alfonso Speaks. If you guys like what you saw, like what you heard, like, share, subscribe. I'll be coming out with more videos very, very soon. This has been a lot of fun. I want to keep this thing going, and I want to talk about some other trials. I don't just want to build this channel around the Darrell Brooks trial, but this is one that I wanted to talk about for a while. But we're going to attack other things as well. Sports, media, politics, maybe. Not a big political person, but we'll see what we can dabble in. But for now, stay safe, stay blessed. I'll see you guys in the next video. Peace.